Let me start. All right, good evening and welcome. This evening's webinar is all about avoiding a claim against your will. And we're going to look at who can claim. We're going to look at ways that we can try and make sure a claim doesn't happen. And if we're aware that a claim probably will happen, how do we minimize the impact of that? So I'm going to go through the content. If you have any questions throughout, please use the chat box. If you're on the recording, there should be a Q&A button to press. That will send me an email and I will respond to you usually within about 24 hours of your question. Hopefully we get through all the questions, but while I'm sharing my screen, I can't actually see the chat box unless I bring it up in front of my face. So I'm just going to leave it minimized and I'll come back and check that towards the end. So please do enter your questions as we go. I may end up answering them as we go, so we'll see. And for those of you who are on live, lucky you, because after the end of the recording, I will actually open it up for you to ask me any questions verbally if you would like to. All right. So who am I? My name's Jackie Broman. I'm the owner of TBA Law. I am a solicitor. So for those of you who don't fully understand the legal industry, a solicitor is a kind of lawyer. A barrister is another kind of lawyer. So we're all lawyers. The solicitors are the ones that tend to work in firms and have clients, particularly private clients, directly with individuals, whereas barristers tend to be subcontractors to solicitors. So I employ barristers to do certain pieces of work, usually court work. So that's how the industry works. Now, the special little logo there on the screen is, you get that as an accredited specialist from the Law Institute of Victoria. So I earned that logo. So I did my master's degree and then I applied for the accreditation program through the Law Institute. It's a 12-month program with a huge exam or 3-part exam at the end. And I passed, yay. So you can do your specialization in all sorts of areas. I did mine in wills and estates, and there's roughly 22,000 lawyers in Victoria. There's only about 80 of us with this accreditation. And the other photo there is because I am also a human, and my two loves are getting away from it all and going fishing, particularly in the ocean, and my dogs are my other love. So that is one of the dogs there. He needs to be chained up when we're fishing because he gets overly excited by the sea foam and he would be overboard in a minute chasing the splash. So yeah, he loves it, but he's a bit hyper. So that's just a little bit about me and what I do when I'm doing estate planning. So as well as estate planning, I do some succession planning for businesses as well around business structures. And I also do a lot of work after someone passes away with probates and deceased administration. And over time, estate planning has changed significantly, and it's no longer just a will, obviously. And particularly when we have more complex family scenarios and we have more complex asset holdings. You know, 50 years ago, we didn't have compulsory superannuation. We didn't have as many divorces and blended families. The Australian dream was really to own your house and have a little bit of savings. So most of us didn't have investment properties. family trusts or much complexity at all. Whereas now life is more complex, and people are more litigious as well. So if they think they have a chance at a claim, quite often they will find some legal advice and find out if they and have a go at it. Whereas 50 years ago it was probably far less likely that that would happen. So this little poker chip here really represents all the aspects that I look into when I do an estate plan with someone. Now, it's not that I necessarily verbally go through it with everyone, but these things are in my process and on my mind when I go through the process. So in the first appointment, when we have our information gathering and instruction, I go through what people own and how they own it. So I get instructions for wills, powers of attorney, and appointing medical treatment decision makers. So those two documents for while you're alive, but if you've lost capacity. Your advanced healthcare directive actually records your wishes for your medical treatment. Superannuation needs to be looked at as well, and it is covered by a binding nomination. Your will does not cover your super. Testamentary trusts, we explore if I believe it's relevant to raise it with someone. There are so many forms of testamentary trust. The minors trust probably is the most common, because when someone has children under 18, we automatically set up minors trusts without much conversation, because they can't inherit until they're 18. So we really have the discussion about, well, you know, how old do you want your kids to be before they inherit? And we extend that age out usually because 18 is so young. Other aspects then of testamentary trusts are, well, can the funds be used for the education of the children? Or trusts are also really useful in blended family situations as well, where you want someone to benefit, but ultimately have someone else own it. We look also briefly at life insurances, not so much TPD, but life insurance. If there are policies, we want to make sure they end up in the right place with the right people for the right use. Instructions to guardians are useful again when there are children under 18, because it's not really the place to put it in your will about how you want your kids educated, what extracurricular activities are important for you for them to participate in, how you believe in punishment, pocket money, all these sorts of things. Family trust appointments. So as I was saying just before, quite often people now have family trusts for investments, potentially to run businesses. So family trusts and what they own aren't covered by your will either. So we have to look at the family trust deed, and we have to work out, well, how do we get the control to the right place? How do we make sure that the wealth you're building in the trust actually goes to the right people as well? A personal effects list, and this is usually a list of the bits and pieces and gifts that someone wants to make. So I encourage that in a separate document rather than the will itself. And then memorial instructions, same thing as well. I encourage that not to be in the will, because again, it's not something that's binding. The only binding bit about your funeral is whether you want to be cremated or not. And it's actually a finable offence if someone does the opposite to what you want. Whereas your instructions around a service, around what you have at the service, whether you have the service or not, is not binding. So it's a wish. And that is why appointing the right people in your will is relevant, to make sure that your wishes are actually occur. So there's a bit of an overview of estate planning. And we're going to dive into claims. So why can someone claim and who can claim? Now, the main focus of this webinar is claims where someone believes they haven't been provided for enough in a will. So this is the most common in many ways. It's the most, you know, when someone has a horror story in a family, it's usually because of this. There are other ways where someone can make a claim against a will, and it's my belief in Victoria that it's going to become more prevalent. This is because in 2015, the law changed in Victoria. So, a bit of history, I suppose, first. Now, in Australia, we have what's called testamentary freedom. So you can do whatever you like in your will. Some countries don't have testamentary freedom. Some countries, the legislation says who gets what inheritance. In some countries, they have partial testamentary freedom. So they can give away, they have control over 40 or 60%, and the rest is deemed by the law. Or it might not be a percentage, it might be certain assets they have control over and others they don't. But in Australia, we have complete freedom. Now, in light of that freedom, the law has developed that if we don't meet our moral obligation, so what society sees as our obligations to people in our lives, then the court can change the will to make sure those obligations are met. Now, this mainly arose because, particularly for women weren't usually asset holders, and so the wife quite often survived the husband and was quite often left either destitute or at the mercy of the eldest child or son. So a father may have left everything to a son to make sure the mother was looked after, and then the mother wasn't looked after. Or, well, that's probably about as far as we need to go with that. But so basically the law developed around, well, if you haven't met your moral obligation to the people in your life, the court can make sure that you do. So there are really good reasons sometimes that someone can make a claim, because if what someone has done is unjust in their will, or they've done it out of anger or some other reason, then that can be undone. However, it's also been taken advantage of as well. So in 2015, the law changed in Victoria, as I said. Before that, it was pretty much open slather in Victoria, and anyone could really make a claim against a will if they thought that they had helped out the person who had passed away, essentially. So a neighbour, if they'd helped with the groceries once a week, you know, the nephew who came and mowed the lawns. So it was really, really very frustrating. It had gone from one end of the scale to the other, where it was just becoming a bit of a joke, really. And the reason it was a joke was because the claims that were being made weren't actually getting to court. They were being settled without a court decision. So the court never actually got to say, well, no, your claim is ridiculous. It was cheaper to make a settlement. And so people just thought, well, it's worth my while to get an extra 20 or 50,000 to do this. So that was the situation. So in 2015, the law was changed and it narrowed down the people who could make a claim. So now the only people who can make a claim in Victoria are a spouse. So if you leave your spouse out, they can make a claim. Children, including stepchildren. So if you leave children out, they can make a claim. Or someone who's financially dependent. So this usually covers someone like maybe a grandchild, or potentially like a disabled brother or sister who's financially dependent. So those are now the categories. So no nephews, no neighbours, none of those sorts of things can pop up anymore. Now, it's not to say that if you're in one of those categories that they're actually going to make a claim, and that's hopefully where we get to at the end of this webinar as well, about making sure that that doesn't happen. But at least you can be reassured that, so I've had lots of people come in thinking that their broader extended family might make a claim against their will just because they'd be unhappy with what they were doing. So we can now reassure people that no, your horrible sister-in-law can't jump in and do anything about it. No, your mum and dad can't do anything about what you've done in your will. So no, if you don't have a spouse or children, you can do whatever you like. You've got no obligation to anyone. So that is the status at the moment. And those sorts of claims are called family provision claims, because someone is making a claim on your will for further provision as a family member. Now, what I'm not really going to cover on today are a couple of other kinds of claims that can be made. So someone can challenge the validity of the will, which is a completely different claim altogether. So they're trying to get the will set aside because either it is questionable about whether the person making the will knew what was in the will, or whether there was undue influence around the person making the will. So that is a separate situation. So this is purely family provision. So what do we do? What do we do? Now, this is where it comes down to using what is in your estate in a tricky way, with some fairly detailed planning. If we get to your planning early enough, we can pretty much make sure that there's very little in your estate that your will would cover. So if your will ends up only covering like a transactional bank account or something like that, it's not worth someone making a claim, because a claim against nothing is nothing. So essentially, that's what we end up looking at. We look at minimizing the assets that could be targeted. And we also look at using superannuation. So if you remember when I was looking at that poker chip on the screen with all the different aspects of estate planning, and I said super is not covered by the will, super can be used in a really interesting way to direct a major part of your assets to a particular person or group of people. And because it isn't in your estate, it doesn't come under your will, it cannot be claimed against. Same thing with life insurance. So if you direct it to a specific person, there's nothing that can be done about that. Other assets that aren't covered by the will are joint assets. So that is a strategy we use a fair bit as well, is getting a second name onto the asset so that when one person passes away, it automatically goes to the other named person. So that's another strategy that we can do. So we look at what is in the estate and how we can maneuver things. Farming families have some extra benefits in some ways, because they still have some exemptions on on stamp duty when they are moving land. Because farmers are often asset rich, owning a lot of land, and they want to make sure that the main assets go to the person in the family who's going to continue the farming. It's quite often that what we'll do for farming families is use trusts as well. So we would start moving assets into trusts while the older generation is alive, and then we transfer the control of those trusts during the lifetime of the person, so they can actually see the benefit of the transfers having happened, and quite often also then qualify for Centrelink pensions as well. And then, as I also said on that poker chip slide, family trusts are also not covered by your will. So it's also another potential tricky method that we can use to move assets and make sure that they go to the person you want them to go to without them being subject or even the possibility of a claim being made on them. So those are some of the things that we try and do from an estate planning perspective. An interesting example was an elderly lady that I saw recently who had sold her house, and she'd moved in with one of her daughters, and was essentially using her savings to pay board at her daughter's house. It wasn't quite to the point of a granny flat arrangement. In fact, it was probably borderline elder abuse, what was going on. And so she was paying board, and she was not really being fed, and she was pretty much just trapped in the house. And this elderly woman's other daughter, because she was interstate, found out what was going on, and the other daughter came and collected mum and brought her home here to Victoria, which is why I got to meet her. Now, the elderly woman didn't have much left in savings at all. She was just getting a pension. So she probably had maybe 150,000 in savings left. Now, what had been depleted was probably another $150,000, which had been paid gradually to the other daughter who'd been caring for her. So what we did in that case was created a term deposit, and essentially moved the bulk of her funds over into that account, only kept about 20-odd thousand in her transactional account. And the term deposit we made as a joint account with the daughter that she was now with in Victoria. So if she passed away, all the funds in that term deposit would go to the daughter in Victoria. The estate would only be about $20,000, and we still left the estate 50-50 actually to the girls in that case. And we're pretty sure that the daughter in the other state is going to jump up and down about it, but there's nothing she can do about it legally. It's done. So that's one example. Another example is a blended family situation, and this was done on the understanding that the husband and wife were working together. They knew that there's an estranged child. One of the husband's kids hasn't been around for 20 or 30 years. But we also knew that they're likely to make a claim just because they can. So we made sure all the assets were joint assets between the husband and the wife. And we also made sure that all the superannuation of his would be paid directly to his wife. So essentially there was nothing in his estate at all, should he pass away first. So that was a bit of the key. So it would have been a tragedy if the two had passed together, because then there would have been an issue. But if he passed first, and unfortunately that's usually what happens for men, there'd be nothing in his estate, and the estranged kid, too bad, so sad, nothing there to claim. So there's some of the sort of things that we can do. Now, there are some situations where you just can't do much. And the problem with those situations then is when a claim does arise, usually when a court case happens, a person can defend their decisions. But unfortunately, in the case of a will and a claim against a will, the person who made the will has obviously passed away, so they can't defend their decision. So what I always encourage is, if we're going to make an omission, we're going to specifically say it in the will. We're going to say that the person has been left out consciously, so not just by mistake. Yes, we've left them out. Yes, we've thought about the consequences of this, and we've left them out for the following reasons. So that can be really helpful, because what the law says as well is, if someone makes a claim, the court actually has to consider the relationship between the parties and the wishes of the person who's passed away. So if the relationship is pretty much non-existent because there's been an estrangement, or the relationship is deteriorated due to violence or theft or all sorts of things that go on, then the court is really going to look at that and go, well, the person who's passed away has no moral obligation to you who's making the claim because of what had happened during their lifetime. Whereas if you didn't have that evidence and other members in the family tried to sort of say what was going on, it's the claimant's word against the families, but the deceased person knows directly. And so any evidence that we can have from the person making the will at the time is really, really crucial. So that is the second strategy, really. Firstly, we have a look at how assets are owned and seeing what we can do in terms of tweaking those, managing those. There are other financial products that we have access to other than joint accounts. You can put more money into super. You could have deposit bonds. You could have all sorts of things that put your savings somewhere where you can still use it for life, but then it definitely goes to a certain person when you pass away and they're not included in the will. So that's always the first strategy, to look at all those scenarios. And then the second strategy is then to minimize any damage by giving as much evidence and reasons as possible in the will. So I've been talking about the estate planning process. Here's our little chip again. So as I said earlier, this is what I do as part of that estate planning process, and what my staff also do, because it's you know, my process. We look at all these things. We, as I said, it's not so much that we go through it with you guys in real detail during appointments. We know what questions to ask to get to the core of what needs to be looked at, essentially. So in fact, a lot of people find that working with us is really quite easy. We don't want to overly complicate things that don't need to be complicated, but we have it in the back of our minds what we're looking for, what are the red flags that stand out for us, what are the strategies we need to engage, and we're not going to raise irrelevant things if we don't need to. The process takes 2 appointments. So the first appointment is where we go through that poker chip, essentially, and we collect all the information. We get to the point where we have instructions from you to draft the documents. So then you go away, we draft the documents, we email them to you within the week. You have a week or so to look over them. So our second appointment then is to sign the documents, essentially. So if we haven't had all the information at the first appointment, we're going to email you the drafts with highlighted bits that we need to fill in. But essentially the goal is to get to a final draft via email, and then we catch up with you for the second appointment to do the signing. Now, at that second appointment, you'll have valid binding documents all done. In terms of delivery of the final documents, sometimes there are acceptance documents that need to be signed by attorneys and so on and so forth. Binding nominations sent off to super funds, all these little bits tidied up. And then once all that's done, we then give you a whole pack of the certified documents. So that's the final delivery. So we do that either electronically or just posting you a physical copy. Now, because we're in pandemic land at the moment, all this can be done via phone and Zoom, no worries at all. There was actually emergency legislation brought in Victoria that we can now sign remotely and electronically. So we can witness documents via Zoom. You can apply an electronic signature and that's valid as well. So there's been a whole lot of changes because of this. And I mean, those changes are good, and I hope they don't get wound back, because it does make life easier for everyone, because who has, you know, half a day to be running around the whole state to go to appointments? So this way you don't have to commute. You do it from your own home, you know, just as we're doing this webinar over Zoom. So yeah, that's the process. So Quite often I also get asked, well, what's the cost? So for a couple, the whole thing costs $1,100. So that is a will each, an enduring power of attorney each, a medical treatment decision maker each, an advanced healthcare directive each, a superannuation binding nomination each. And quite often we also review a family trust if there is one as part of that as well. So it's all inclusive essentially. And so that's the pack for a couple. For an individual, it's between $750 and $880. So that's what you're looking at for an individual. And if you don't need powers of attorney, you know, we can give you specific prices depending on your situation as well. But that's the standard package for the ordinary couple essentially. So there you go. Thank you very much. I'm going to put my email address into the chat box so you can cut and paste that if you want. By all means, email me if you have like a broad question. Happy to answer 1 or 2 questions. I usually do that within 24 hours, like I said at the beginning. But yeah, really appreciate you hanging in there. And hopefully I'm now going to open up the chat and the questions to see how we're going. The little feature's not working. There it is. Okay, chat. What about grandchildren? Can they claim against your will? No. So, so that's the short answer. Lawyers usually don't give you short answers, do they? So no, a grandchild generally cannot make a claim against your will. Exemptions to that. If you raise the grandchild like your child, so the child either thought you were their parent, or their parent is pretty much, you know, non-existent or hopeless. The other scenario is if your grandchild falls within that other category of someone who's financially dependent. All right, so those are the cases when a grandchild can claim. Now, there's another scenario when a grandchild might be entitled to something under your will, and that is if a will has been written poorly and says, I give things equally to my children, and then doesn't say anything about what happens if one of your children passes away. So if one of your children passes away, the portion that the child would have had automatically goes down the line to their children. So your grandchildren are entitled in that situation. It's not a claim against the will, it's an actual entitlement that arises. So if you've had a child pass away and you don't like their children, you specifically need to say in your will that it does not go down the line to the grandchildren. All right. My binding nomination is to my estate. Does this mean that my super reverts back to my will? Yes, it does. Yes. So your super does not automatically get covered by your will unless you direct it to be. So yes, that does mean that it goes back to your will. So yes, that means that your super then can be at risk of a claim. So that just needs to be looked at a little bit closer. I'm recently separated. Is there any point in changing my will before I'm divorced? So if you've had a financial settlement, then you're safe. If you have not had a financial settlement, your ex can make a claim on your will. So at least you have a will. If you are separated and didn't have a will, then you definitely have to do a will, because the law of intestacy automatically includes any spouse, whether you've done a financial settlement or not. So if you die without a will, people can also make a claim for provision in that case as well. So if you've separated and you have kids and you die without a will, your first $450,000 goes to your ex-spouse. If you've got a current spouse as well, then it's divided between them. The kids get the little dribbles at the end. And so if the kids believe, well, that's not enough provision for me, they can make a claim. If your new spouse thinks, well, that's not enough provision for me, they can make a claim. So it is just a phenomenal mess if you don't have a will in that scenario. But if you've separated and you've done your financial settlement, no rush for a will. If you're separated and you haven't done your financial settlement, yes, you need to do a will. Can estranged adult siblings make a claim? So is this meaning your brother or sister? So your brother or sister can't. So your siblings, no. Your adult children can if they're estranged, but no, not a brother or sister. Do binding nominations have to be updated regularly, or will they stand written regardless of how long? Depends on your super fund. So industry funds expire every 3 years, so you need to redo them. Some retail funds allow you to do what's called a non-lapsing binding nomination, so it doesn't lapse after 3 years. Self-managed super funds, you're pretty right to do a non-lapsing one as well. So you just need to check with your super fund. Does my super binding nomination become invalid once I marry? No. Your will does, your binding nomination does not. All right, I had a couple in the Q&A bit as well. Okay, how do I choose the executor? Yeah, that's a hard question. Your executor can also be a beneficiary. You can choose an executor that is not a beneficiary. It doesn't matter if they're an executor or not in terms of being able to make a claim. If you're worried about executor commission, that's a different thing altogether. Executors don't have an entitlement to commission. They can ask for one and it can be up to 5%, but they need beneficiary consent to get it, so they can't just take it. So yeah, if your executor's not in those categories of a spouse or children or financial dependent, then they can't make a claim. Our super has recently been transferred to an annuity, which we draw on each month. Is an annuity treated the same as super? Depends on the financial product that you're using. So some supers, when they're converted into pension phase, it's still considered super, excuse me. So you would still need a binding nomination if it's in pension phase. If you've completely taken it out of super and put it into an annuity investment itself, there are some financial products that allow you to nominate who the beneficiary is. Otherwise, no, the residual that is left when you pass away of that annuity, yes, it will be part of your estate. So if it's a pension, then it's super. If it's a different kind of product, you need to check which sort of product it is. How do you provide evidence when leaving a relative out of the will? So the evidence that I ask for is a brief statement in the will itself. So, you know, I exclude such and such a child because I haven't seen them for 20 years. So that would be sufficient explanation in the face of the will itself. And then I ask for a page or two of a more detailed statement that I keep hidden, so no one actually sees it unless it's needed. So it's kept in with the will. And what I ask for in that sort of statement would be things like dates around events that happened, things that were said, those sorts of things. So if the estranged child has said, I hate you, you're not my family anymore, and I never want anything from you ever again, those sort of words need to be put in along with roughly when they were said, as in, you know, month and year, something along those lines. So if someone's stealing from you, those sorts of things get put in, what you notice was stolen and when. So yeah, that sort of evidence. So that's a whole lot of questions. That's really great. Thank you very much. So if there's nothing more urgent, I'm going to stop the recording because, as I said, I know what I was going to do is pop my email in here first. It's easier for you to cut and paste from the chat screen. So you can cut and paste from there. Good.